Greetings, Earthlings. May 11th, 2016. This is my first reading from my book, The Banker's Secret, Chapter 1. In 2009, I had been a lawyer for about 5 years. Naive still, although much less so than when I started. I was more successful than most GED graduates. I was doing pretty well out of the gate, but I was nowhere near famous. In the routine daily course of my civil litigation practice, located next to, of all things, the Fetish Factory, the time came that I was hired by a gentleman of African American heritage to defend a foreclosure. My client's name was Dennis Brown. Our foundling allegiance ultimately grew into something I will never forget. It was a humble and innocent foray toward the dawn of comprehension of the monstrous malfunctions of MERS. Stay tuned! My signing up to help Mr. Brown was a rather inauspicious beginning to a revolution. In a foreclosure, of course, a bank is trying to take someone's home or his or her real property and appurtenances. The bank is the plaintiff, just like the plaintiff Joe Blow in the proverbial dun-dun-dun, the People's Court, whose dry cleaner burnt his clothes. Dumb Bob dry cleaner, like Dennis, would be the defendant. As most people, momentarily including lawyers in that category, would have in 2009, I didn't figure there were too many defenses I'd have a good chance with representing Mr. Brown in the case. Just like one would envision, on the surface of things, the bank as plaintiff had brought suit claiming that defendant, here Brown, had not paid and that as a result the bank had the right to take its collateral, which is of course the house. Upon non-payment it is contractually entitled to do so, subject to certain minor conditions. My clients had stopped paying. That's, of course, the main point in a foreclosure. Where a borrower hasn't paid, for the most part, the rest is window dressing. The bank, if challenged, does have to prove that it sent written notice, whether by hook or by crook, sent written warning to the borrower at least 30 days prior to filing suit. That's about it. The bank's case consists of non-payment and a demand notice. Doesn't sound too rigorous, does it? Although initially not optimistic, I tried to do my job. One element that seemed to be missing was the relationship of the plaintiff to the loan. Along those lines, I noticed something odd. The bank described as the lender in the loan documents, ABN Ramrod Inc., I believe it was not the plaintiff named in the court papers. That was City Mortgage Inc. There must be some explanation, I imagined, but I wanted to hear it. Grasping, as I thought I was, at straws, but intending to make the bankers check the boxes, I sent the lawyer a request for production of documents, formally demanding whatever paperwork gave Citi the right to collect on a note payable on its face to some other bank. I wanted them to send me the transfer documentation, which is usually in the form of something called an assignment of mortgage. Enter the now infamous law offices of David J. Stern. As many of you have surmised, said law firm was the attorney of record for Citi Mortgage. At the time, I didn't know Stern from Adam. After sending my routine request, I heard from the Stern lawyer, well, crickets. Formal follow-up was followed by more of the same, a redundancy of silence. I even went to court a couple of times to see the judge and obtain an order from the court that such document be provided. It was ordered, but Citi Mortgage continued to dally. I don't trust them, Mr. Trent, said my erstwhile client. I began to perceive at that point the type of storm the umbrella, now ARC, with a C, in the Citibank logo is used for. Meanwhile, still thinking our legal defense prospects rather doubtful, I repeatedly instructed my client to post his mortgage payments to my trust account so that when the time came we could hopefully negotiate a reinstatement of his loan, which I anticipated would cost money up front. He complied, although not to the extent I would have wished, and the months flew by without any real activity in the case. In 2009, it was time for mediation. That, strictly speaking, is where the two sides meet in a room with their attorneys and a neutral person whose job it is to encourage the sides to reach a settlement, that is, to resolve their differences, and they all try to do just that. In our case, it was more like mutual Armageddon, refereed by totally ineffectual substitute librarians. I went into the room mediation morn with the desire of saving the American dream of one lower middle class family, and having fully prepared myself to beg and kiss ass. The bank's attorney was a milquetoast from Stern's office by the name of Greg Dreilinger. Our singularly non-threatening, moderately professional, and at all times slightly friendly, Opponent was so very kind as to admit there had been an error in the application of Mr. Brown's payments, such that he, Brown, was entitled to a small credit against the ever-mounting debt, onto which various types of charges were being tacked, such as attorney fees and exaggerated claims for expenses. Mr. Dreilinger presented Mr. Brown with reinstatement terms. They did not require a hump sum up front to catch up, sick. Instead, there would be a slight increase in the Browns. There was a Mrs. Brown, monthly note, sick. Dennis Brown was having none of it. And I asked, why the payment increase? The answer, to keep the loan maturity date unchanged. The date of the last payment provided for in the existing loan documents could not be modified. The next answer I would get was the first hint that I would get that something was just not right. It was my introduction to the beast. The answer to my predictable, unimaginative next question was the first oddity of many, the combined effects of which would take over my life. Literally, in Mr. Brown's case, and more figuratively in a grand, universal, spiritual, and lifelong sense, I was about to get my assignment. In response to my inquiry as to why the maturity date was set in stone, Dreilinger replied that it was due to the investors' rules. Come again? Something called the investors' rules is going to keep us from settling this case? Last I checked, there was a plaintiff and its lawyer, and a defendant and his lawyer, and one day soon at this rate a judge in this case. But as far as I know, we ain't got any investor running around here, do we? In this court-ordered mediation in which all parties having full settlement authority are required to be physically present with their counsel? Demurred Attorney Drytoast, as he stepped outside very subtly for some sotto-voce cell phone machinations with someone or something of unknown provenance. The mediation was declared an impasse. As we departed, my clients and I faced the prospect of a looming trial date, one at which we would not be entitled to a jury, and instead would face the judge. Now I would have to figure out some legal defense to the foreclosure, and I would have to do so fast, all because of something I had never heard of before, the investors' rules. A secret force was acting behind the scenes, crushing my client's prospects and seemingly hell-bent upon bringing my client's American dream to a nightmarish conclusion. That force, without even having to identify itself, was putting the screws to me in the process. We've gone from due process to screw process. I was pissed and starting to get nervous, and I hauled tail back to my office for some late-night file review. As I drove, I tried to remember if I had ever gotten that assignment of mortgage from Greg Dreilinger. It turned out I had.